Hey everybody, in this talk, I want to explain what Wisconsin courts consider when deciding custody. Custody of kids is an issue that typically arises when couples are divorcing or they're involved in a paternity action. And when a minor child is at issue, the parties ask, who gets custody? How can I get sole custody? Or how can I get joint custody? And if you're someone who's involved in a court action involving custody in Wisconsin, then this talk is for you. I'm Kyle Kaufman. I'm an attorney and owner at HKK Law Offices. I've been practicing for more than 20 years. Now let's start by clearing up some terms. Custody. It involves decision making, all right? And it's major decisions. We're talking about school, medical care, religious upbringing, and other major decisions, such as activities. Let's talk about sole custody. Sole custody is when one parent decides. And then there's joint custody. And joint custody is when both parents discuss the major decision and decide together. There's another concept that's called joint custody with impasse breaking authority. And this is when both parents discuss the matter and one parent decides because a court has given them that impasse breaking authority. Now, custody differs from placement. Placement is about where the child lives. What home do they live in? When does the child live there? For how long? Where do the exchanges occur and when? When we're talking about placement, we have primary placement. This is where one parent has 76% or more of the time. Another type of placement is shared placement. This is when each parent has at least 25% or more of the time. And then the other concept is called equal and shared placement, and this is the classic 50-50, 50% each. Now, what we're talking about here is evaluating this in a 14-day cycle, every 2 weeks. And we're counting overnights. That's how you arrive at the placement. Another term, and I alluded to this earlier, is 50-50. Now, people a lot of times say, well, I have 50-50, and what they're referring to is custody. And what that really means under custody terms is joint custody. And this is where, again, two parents discuss a matter, and then they make a decision together. And in placement, when we say 50-50, we're talking about equal and shared placement, sharing equally the time with the child. Now, here's some different type of equal and shared placement scenarios that you might be familiar with. One is 7 days on and 7 days off. So 7 days with one parent, 7 days with another. That's not that common. What's more common is where it's a little bit mixed up, where you might have a parent who has 2 days in a row, then the other parent has 2 days in a row, and then one parent has a full weekend, like a Friday till Monday morning, and then that repeats with that weekend alternating. So custody and placement, is it all the same? My answer to that is no, in that custody is decision making, and placement involves who the child spends time with and when. Custody and placement is similar, however, in that the factors in determining custody or placement are the same. In other words, what a court does in asking who gets custody and who gets placement, the court considers the same factors. The overall guiding principle or factor is what is in the best interest of the child. Now that is a concept. It's a concept based on the totality of circumstances as directed by the guidelines and factors that we have in our statutes. Now, the court's going to review these statutory factors and consider arguments of the parents and their attorneys and the recommendation of the child's guardian ad litem. And based on all that, the court will make a decision. Now, here are the factors, and I want you to take notes because these are important. The first factor is the wishes of the child's parent or the parents as shown by any stipulation between the parties, a proposed parenting plan, or any legal custody or physical placement proposal submitted to the court at a trial. Another factor is the wishes of the child, which may be communicated by the child or through the child's guardian ad litem or other appropriate professional. Now be careful, it's not often that a child actually gets to show up in court and actually say what they want. The third factor the court looks at is what's called the cooperation and communication between the parents and whether either party unreasonably refuses to cooperate or communicate with the other parent. Another factor is whether each party can support the other party's relationship with the child. The court looks at whether or not the parents are encouraging and facilitating frequent and continuing contact with the child, or whether one party is likely to unreasonably interfere with the child's continuing relationship with the other parent. Another factor you need to know about is what's called the interaction and interrelationship that the child has with his or her siblings and anyone else who might significantly affect the child's best interest. The court is also going to consider how a child interacts and interrelates with his parents or her parents, and the amount and quality of time that each parent has spent with the child in the past. The court will look at whether a parent is going to make changes to their custodial roles, including lifestyle changes that a parent proposes to make to maximize placement with the child. A court will look at the factors of alcohol and drug abuse and if there's a significant problem. This applies to the parties. It applies to a person with whom a parent of the child has a dating relationship, a significant other. It applies to a person who resides or has resided or might reside regularly or sometimes in a proposed custodial household. Now, a child's adjustment to home, school, religion, and community is also important, and the court's going to look at that factor. The court is going to look at the age of the child. The court's going to ask about the child's developmental and educational needs at different ages and apply that as factors. Another factor you need to be mindful of is whether the mental or physical health of a party, a minor child, or another person living in a proposed custodial household negatively affects the child's intellectual, physical, or emotional well-being. A factor a court will look at is whether any of the following has a criminal record or whether there is evidence that any of the following people has engaged in abuse of the child or any other child or neglected the child or any other child. So they're going to look at whether the parents have done that. They're going to look at a parent's significant other. They're going to look at who resides with the parent or has resided with the parent in the past or might reside with a parent in the future. A factor to look at is whether there's evidence of interspousal battery or domestic abuse. The court will also review reports of appropriate professionals if they're admitted into evidence. And finally, the court looks at any other factor that the court determines to be relevant. Wisconsin judges are required to make decisions on these factors. What you need to do is to frame your presentation to the court, keeping these factors in mind. You want to make sure that the facts and evidence fit at least one of the factors. So if someone challenges you in court on relevancy, like, why are you bringing this up? Why are you talking about this? Direct their attention to the factor. So for example, say you want the court to know that you have a concern about, let's say, the father's new girlfriend. And when the other side objects and says, why is this relevant? Make sure you point out to that factor to the court that says that the court is to consider significant others and their impact on the child. So if you have a story or an event to talk about how that person impacted your child, it's relevant. And make sure the concern you have is valid and it's related to one of these factors, right? Think of things like alcohol or drug abuse, criminal records, battery, domestic abuse, a mental health concern, physical health concern. Keep in mind that it's your job to give the facts to the court. Note that these factors do not have a time frame attached to them. That's important. In other words, the factual event may have been many years ago. Nonetheless, that event or fact can still be submitted to the court. So let me explain this a little bit further. Let's say, for example, that a father had a drunk driving conviction 1 year ago. I would say that's pretty relevant to your case when you're in court. Now, if the father had a drunk driving conviction that was 20 years ago, that's probably just less relevant, assuming there's been no updated alcohol abuse. So the court has to decide what weight to put on your facts. What I don't like to see in courts is when parties don't tell the court about events. They simply leave it out thinking that it's not relevant or it's too old, and yet they somehow expect the court to know everything about their lives and their children and their experiences. Don't leave it to chance. The court doesn't know you. The court only knows of the record that you make before the judge. So tell the court the facts that are relevant to the factors. Now, we want to hear from you. What are your questions on custody and placement? Leave a comment for me below. And if you want to take a step further, schedule a consultation with me or one of our attorneys at hkklawoffices.com. Thank you. Take care. I hope you enjoyed this talk.